Robert Evans has had to leave us, obviously, to go and introduce one of the next papers. And I want to move the discussion on now to a slightly different topic. Geeta, in your paper this morning, you raised the idea, the concept of some sort of higher rights for individuals in the environmental law context. Do you just want to introduce that first, and then we'll discuss it?
Sure. So one of the things that I was discussing was the limitations that we're seeing in terms of the more procedural rights that we have, such as environmental impact assessment and strategic environmental assessment, which are being looked at in very sort of, I would say, narrow procedural terms, rather than considering the basis for which those rights were created, which is effectively a substantive right for protection of the environment, or in the Articles Preamble context, it says a duty to kind of preserve or protect the environment for future generations. So it seems to me that what our system really needs is some kind of constitutional recognition of this substantive right, of the value of a healthy, thriving environment that can then be weighed against other substantive considerations, for example, economics or growth or those sorts of things. So I think that would be a really, really crucial step forward in terms of actually addressing some of the concerns that we're seeing.
And just to sort of be clear on this, how does one then resolve conflict or potential conflict between some higher right and what I'll just loosely call kind of domestic law?
Sure. Well, I would foresee it as something that's very similar to the human rights that we have. So there you have protection of certain rights. Some are qualified rights, so they're weighed up, and you have a proportionality standard of review. So you recognise there's an interference. Is it proportionate to the aims, and what are the harms? So you have an ability to actually look at more than was it irrational, was it mad? You're actually looking more at a more proportionate review of a decision.
And Simon, you this morning obviously took up some of those themes, but from a slightly different perspective.
Well, I think that higher or more international regimes are really important, so as to show people that our system is fair, because it matches to the standards of European environmental law, to the European Convention on Human Rights and the Aarhus Convention. I'd be sort of cautious about introducing something which sounds to me a bit like a general duty to make sure that development is sustainable, which probably does no more than reflect the NPPF. And I think a lot of European environmental law has been extremely difficult to address in practical terms, particularly the Habitats Directive and Birds Directive set tests, which are very difficult, and I've been worried that we'd go down that direction.
But you also made the point this morning in your paper that where is democracy in this? Don't we actually elect governments to make
Yes.
broad decisions?
Yes.
And if people don't like those, they have the opportunity through the ballot box to remove those people, and therefore actually domestic law does in that sense reflect the will of the people. And I just want to understand how how that relates to Geeta's idea that there are some things that transcend all of that.
Well, I absolutely resist the idea that in a properly functioning democracy there are unwritten moral principles that somehow transcend the application of law, because climate change...
The spirit of the law, the letter of the law.
Well, the application of the law, because yes, climate change is incredibly... we need to get to grips with climate change, but that has to be through the operation of democracy, in the same way that there's an absolute need to provide homes for people to live in. That's an absolute need. We're not saying that people can build homes without the need for planning permission, but somehow there's this sense that there's a higher law where someone can take a view on shale gas, which actually isn't, as we heard this morning, necessarily accepted by everybody, and that's a basis for ignoring our domestic law, which has been created through a democracy working under the rule of law.
I have to say, I think the place for these big issues is policy. Is, and that is where democracy should be. I would go as far as saying that the place for democracy is not actually in planning decision making. I think that should be a process. That should be a weighing of issues. That should be informed by
The setting of the policy above that.
democratically formed policy. Because you have these debates at a decision-making level.
Are we
some
going
of the
there
issues
through the
some of the
national
issues
policy
are too big.
statements?
Some of the issues are too big for a decision-maker to grapple with in one isolated project.
But,
Well, I
Jake,
think
this is your area, isn't it? I mean, Shale, from FOE's
Yes.
perspective, I mean, any comments on
Yes.
the lawyers here, the private sector lawyers?
Yes, I mean, I suppose a couple of things occur to me. I think the first thing on Simon's point is that it seems to me that the courts play an integral role in the upholding of our democratic rights, and I don't really understand the implicit idea that somehow the courts are in some way sort of subjugated to the role of the legislature or the role of the executive. They're all equal partners, and the courts have a role in sort of adjudicating on whether those other two chunks of government are acting lawfully. I think it's the first point. On the second point, I do take Duncan's point, and I have quite a lot of sympathy for that actually. But at the same time, it seems to me that we are moving increasingly to a system, particularly through the Human Rights Act, where the courts are actually adjudicating on fundamental rights, whether we like it or not. And the question is, I think as Gita puts it, is whether you seek to redress that sort of rights-based system or add to that rights-based system with a further right that protects the environment.
And it would be a legal right, not a moral
Right.
right, and it would be also, it would be a domestic level right. And I think I really was struck by what one of the commentators this morning was saying, one of the people from the floor, your definition of democracy. I mean, I totally agreed with his definition, which is much broader, which is much more than simply electing people and then expecting them to, deliver on the entire democratic process. You have local democracy, you have abilities to engage at local level on things, you have ability to be part of wider discussions, and I think all of those things are really important and for a healthy, engaged, vibrant democracy. Otherwise how will people, I mean, you have a massive issue of disengagement at the moment. I think the referendum in Scotland, was a really powerful example of how people can be engaged if they feel like they can make a difference. 85% turnout, and trying to draw from some of the lessons of that to engage and enliven our process, which is becoming stultified, which is becoming a huge separation, I think, and an alienation on the part of the vast majority of people from the people that are electing them. I think those are all really core, very worrying concerns if you want to have a thriving democracy long term. And I think the answer is to enable more engagement, not to say, well, actually we elect people and they will go on and do what we want them to.
But sort of take issue with where a local authority has granted planning permission for a development and no one has challenged that, and then you have civil disobedience to try to prevent the recipient of the planning permission actually doing what it was authorised lawfully by the planning permission to do. There was democracy at local level, applying policies that were arrived at national level.
Can I move this on to a slightly different point now, but very much related? In the papers this morning, there was discussion of civil disobedience, and I know no one would want to condone criminal activity, absolutely not, and I know FOE, as you said this morning, very much acts through the legal system. Indeed, your point, one of the points you made, Gita, was about ending the criminalisation of environmental action, not encouraging criminal activity, but it is, we know from experience, and Simon gave another number of examples, whether it was Swampy or people since Swampy, of civil disobedience. And I just want to sort of throw that back open for discussion. Quite a number of the questioners in the session this morning seemed to me to have some some sympathy with civil disobedience being appropriate in some circumstances. And I invite comment on that.
Well, it's everyone's own moral decision what they do. They just have to live with the consequences. So if your personal moral decision is that you want to stand in the road to resist something rather than stand for Parliament and do something about it through the elected route, then that's your personal moral decision. But you have to take the consequences, which is you've committed an unlawful act and be punished accordingly. And I don't see that you can go to the magistrates' court and plead for something other than punishment for the offence that you've committed, particularly if basically you're resisting something which has been through a system which is basically fair.
It's a tricky one, isn't it? The question is, what is the line to be drawn here? People must be able to protest something they don't like. We encourage that openness, read it all. If you don't like it, say so, give your reasons, let's have a debate. The question is, at what point are we no longer having a debate and people are actually taking action, which is regarded as, if not criminal, it's certainly, protest has just gone too far there. You're no longer being part of a system where together we'll come up with a consensus position. There will always be objectors, I think, to every major decision who at the end will not be satisfied. What's important for us is that we have a system whereby, even though they know they haven't got whatever it was they wanted, they haven't got the development they wanted, or they haven't stopped the development they wanted to stop, they accept that they've had a fair say, it's been taken into account, and while they don't like the outcome, whatever it may be, they accept it to that point. When you take a step further and say, despite that, despite the system working in that way, I'm now going to take further action, that's where we really need to say, well, what was our system such that those people felt it didn't give everyone a fair hearing?
And it actually is, more from my recollection, a feature of civil disobedience actions that people were perfectly willing to go to jail. And they understood that that's what they were
Good
doing, but
publicity.
they were challenging. Well, they were challenging the laws themselves as unjust, or they were challenging a wider cause for which they felt they were prepared to go to jail. And I think there are real parallels between that and some of the climate protests we're seeing, for example, protests on shale or other things. There are people who feel it is a matter of conscience that they need to take a stand and that they are prepared to go to jail because they think there is a wider, bigger issue here that needs, that they feel a moral imperative to act on.
But I mean, Simon, in the sort of debate this morning when we were in the main conference hall itself, you drew the distinction between, if I can summarise it very briefly like this, look, being unhappy with, for example, fracking or something like that, and you said that can't really be compared with the great struggles of Gandhi or Mandela or others in the civil rights movement, and Gita didn't wholly accept that point. But so explain that.
When groups look at proposals for exploratory works in relation to shale gas proposals, works which potentially don't even require environmental impact assessment, and we saw the way in which early proposals were treated by local authorities. Now they've become so politically sensitised, and you get these very broad statements, which I think themselves lead to fear and public disquiet. I worry that that sort of statement, it can easily be applied to people who object to greenbelt development, to large housing development. We see people take against particular chain stores, the anti sort of globalisation sort of movement, etc. I just really think that it's a slippery slope, and we need to be cautious before we say that any particular form of development is so sensitive that it should be treated in a different way. And frankly, I think we've all got a bit hot under the collar about shale in a way that I find the reasons given in Catherine's paper this morning, was slightly surprising. We need to be careful before elevating this to an issue that's equivalent to Indian independence or the civil rights movement in America.
I take that, but on the other hand, it doesn't seem to me, actually building on your point earlier, Rory, I mean, it doesn't seem to me that the protests, for example, around shale are actually being handled differently. People are being arrested in the same way, including, MPs in the case of Caroline Lucas. There's a lot of law out there that criminalises protests and that deals with protests and enables a democracy to respond to protest in a way that it thinks is proportionate. So in some ways I'm not entirely sure there's a problem because, there's all sorts of bits and pieces and ways and means to deal with this, isn't there?
Well, the problem may be if I'm not focusing just on shale, but the problem is if the promoter or the international investors behind a particular form of development just decide this is not worth the candle, because even if we get our consents, it's going to take X years to get, and we will never have a social license to use the phrase this morning, to actually be able to do this without interference at every stage. We're going to take our money elsewhere, and when the government has said, well, actually our policy is, go for this, individuals have just scared away the opportunity to deliver on the government's commitment.
But that what you've just said is quite important, isn't it? The government's policies to go for this. I mean, it's almost as unsophisticated as that, and it's almost. I mean, I'm support the principle of exploring shale gas, but I think protest is actually why we should worry about it is because it's a symptom of an ill system. And going back to my point about the importance of policy and democracy, people, I think, where shale's concerned, haven't been brought along on the journey that the government's gone on. And either, you could argue that the government's got there too quickly. I'm not even sure that's the answer. It's got there just without.
But there is a media-driven
public
thing
engagement.
there. The public do not understand, or it's not portrayed in the media accurately.
But the government's done nothing
as to what is actually happening.
What's the government done to try and? I mean, I think government. I go back. I do a lot of airports work. It's the same thing. The government's got a responsibility to lead, but to engage people along the way and help them understand policy and how it should be shaped, and actually give them an opportunity to shape it. I would like the government to end up with a pro-airports policy, but at the moment, we all know that's being kicked around in the long grass, and we've got an independent commission looking at it, which none of the politicians are willing to say that they will endorse. So, I just think the lack of leadership is at the root of a lot of the problems with the system.
I agree, but I also think it's a really interesting contrast, isn't there, between, as you say, the Airports Commission, which may well be a political creature, it may well be a function of, the coalition, as you say, the nature of our system, the compromises that we make. But there's a big contrast between that process and the processes that we've had around shale in the last 4 years. Where, as you say, the two are really not really comparable in terms of public participation, or, I agree with you, dissemination of information. Yeah.
And then you have the wider thing of, the government wants to, if it wants to promote airports, if it wants to promote shale, if there's genuine, I think what was presented this morning was one side of the shale argument, and I think there was a kind of quite delicate dance around, shale versus coal and oil, and shale versus renewable, and one isn't a competitor, and I think actually that is, that we would take it, don't want to turn this into a substantive debate of shale, and obviously the person here isn't here, but actually there are really behind that, there are some really very fundamental assumptions, which you then do come back to, and that you aren't going to, it's not a question of, you can explain, people can take a particular view on these more fundamental issues, and where they are fundamental because they relate to future.
Rory mentioned earlier the national policy statements under the 2008 Act system, and one of the things that people have said about those, one of the benefits that's been put forward of the national policy statements is that they set out clear statements of government policy, what is to be done, whether there is a need, and how that is to be tested. Now, people might like the outcome of those national policy statements, or they might not, but they are debated in Parliament, they're endorsed by Parliament and then designated, and people do therefore, within the democratic process, have the opportunity, as Duncan said before, to set policy. Now, is that a model that should be used more widely, that we have the debate, we decide what the policy is, and then we do get behind it, or even there, is there some sense that, no, I don't like the result, so I'm not going to accept even that element of policy. Jake, I mean, you
It's
thoughts
very
on
interesting.
that?
A very interesting question. I mean, I think we do have concerns about MPS. We certainly have had concerns about them in the past, and I guess at the moment we have to bear in mind that this government came in on a localism agenda, and therefore actually decided that it was going to downgrade the importance, the significance of MPSs. And one of the concerns personally I have about Shale, sorry to bring it back to Shale, is that what a government has effectively done around Shale is come up with a series of documents which taken together have in effect dealt with the things you deal with through an MPS, but not through the procedural mechanisms that apply to an MPS. So you have planning guidance, and you have various statements by senior politicians, and you have guidance that sits around the licensing process, and you have various instructions to regulators. And these documents individually, in effect, deal with exactly the points you're describing, but not in the way and not with the same procedural safeguards.
Okay.
And my understanding, and I'm by no means an expert on MPS, but my understanding is actually the public role in terms of the discussion, parliamentary stage, is pretty limited, and then by the time you get to the point where it's implemented at local inquiry, there are very many issues that have effectively been decided at that other level, and that in terms of cross-examination of those kinds of issues, that's also very limited. So you have a narrowing down of the public engagement in the process at both stages.
Well, we could probably end up with quite a
quite
debate on those issues alone.
I'm not sure that's true with the NPS. What perhaps is true is because the public do get consulted on the NPS in its early stage, formative stages, typically ones that have been going through already. Perhaps there is an issue here, and that permeates beyond policy to decision making, actually, about how you reach the people. Is it enough to publish on the Department for Energy and Climate Change's website your intended policies and just signpost it on the government news bulletin or something?
Yeah, and hope that
Or a
somebody...
ministerial statement in Parliament?
Yeah, and I hope that somebody in a particular area will realise that there's something in there that will get decided that will mean that when it comes to their area, they can't really
But I
reopen
mean,
it.
does it come back to the point that we were touching on before? I mean, there is obviously a very clear process for people to play a role in making representations on the formation of policy, but it's this almost this higher principle that there are groups who, whatever the result, won't accept that if that is not their position, and that maybe is a fundamental issue for us, that as a society there are some elements who even until the lifetime of the end of a parliament aren't willing to accept because they feel something is I don't know, too important, or a higher right, or something of that sort. And maybe we can just touch on that as a sort of final theme on this before I kind of begin to wrap things up. I mean, is that what it comes down to? We can have the debate, we can take things into account, but if I don't like the result, then I'm very sorry, I'm not accepting it. Is it as crude as that?
It does. We talked about third-party rights of appeal, and my concern is if objectors did have a right of appeal from resolution to approve by the local authority, objectors would equally not accept the outcome of the right of appeal, and we would still have challenges to the court. The fact is, whether we're for something or against something, our views very rarely change through the planning process. As I think as a country we've got, as I said earlier, pretty intellectually arrogant about the correctness of our own views, and if anything, when we learn more, we use the information we learn in order to fuel our pre-existing prejudices and assumptions.
I think some people will change their view, and it's very often where they don't, in the first place, have a very strongly held view, and they learn more information. There was, this morning, we were getting new information, new facts behind it. I think some people will change their view when there's enough public information available,
As long as they haven't
and they can consider
reached
it. And even if they don't change their view they have a much greater not sympathy, but understanding of the counter view. They can see where they're coming from, and they understand it more. And I think that's a very important part of getting to a system whereby if the outcome is something which they still disagree with, they will accept it. Don't agree with it, but accept it.
And why is it, my question would be, why is it not a problem if a developer does that? You know, developers do that. They don't accept a particular a refusal by a planning authority. They can make a third-party appeal. The system enables them to do that. They can bring a JR. The system enables them to do that. And I'd go back to actually Baroness Hale's quote that I mentioned. You know, she, senior member of the judiciary, effectively saying there's a problem here. I don't think, you know, she effectively says if there is any problem at all, I'm not sure there is one. She says it's not sort of NGOs or communities or individuals. She actually thinks it's private bodies, even if there is a problem.
Yeah.
That's what which
It's
is
because it goes back to, you know, fundamentally what people's personal views are about what you said in your presentation about the common law view of life or anything else. Because you know, my own view is we should all be allowed to do whatever we want to do in life, unless there's a good reason for a law to be introduced to stop it. And therefore, if I own land, then I should be allowed to do what I want with it, unless democratically laws have been passed to prevent me. So it's misleading to talk about unequal balance at the moment in the system. The fact is, people with land interests want to do something, they're being prevented from the planning system from doing it. It's right that they should have a right of appeal from that decision. They shouldn't be allowed to do it. That's completely different from looking at it the other way around, but that's probably another episode in this.
Well, exactly, and on that I'm going to, I think, draw things to a close. Geeta, Rory, Jake, Simon Duncan, thank you very much, and Robert in absentia. I hope you've really enjoyed this panel discussion from the Joint Planning Law Conference 2014. Thank you.